as little things. Yes. We have our own email system. We don't use Outlook or any of those kind. It's our own. Yeah, it's kind of cool though because like this is my actual. This is this is my actual email, but then so we have all these different kind of folders in our email. So we have a classified just for people who work in the district and send anything in it. We've got school specific, so you can do. We've got like a health file that you can do emails just to, and you can subscribe to whichever. It's kind of cool, but at the same time, it's also kind of fun. Um, they finally save the time so I can get to the email because I stopped using the internet to get into it. No, it's totally different.
All right, I think we're going to go ahead and start. We were waiting on a few stragglers, but we're going to go ahead and get started. Dave Marcy is my favorite attorney, and he's going to be giving a presentation today on investigating, reporting, and handling child sexual abuse claims, and he's got a lot to share, and make sure you ask him lots of questions. These are starting to they're being reported more often, and they're costing more money. So he's going to talk about how we can get ahead of that, hopefully.
Can everybody hear me? Is that no? I know it's good. It had a stand on it. I didn't know if it would work if I put it in the thing. Okay. Can anybody hear me now? Okay, great. Welcome. I appreciate the opportunity to be here. I'm probably, 15 years deep into representing FSBIT insureds, last 12 years consecutively. At one point or another, I've represented all 13 of the member districts. So just a little bit about me. I started my career in law enforcement, where I spent 12 years as a police officer and a detective, where I investigated crimes against children. I spent almost 4 years as a child sex crimes prosecutor, and then I've got about 15 years of experience defending and litigating allegations of improper conduct against children, whether it's child abuse, whether it's student-on-student misconduct, student-on-student sexual misconduct, or misconduct involving staff members. So we're here to tell you a little bit about a handful of things that we believe will help you in your districts minimize risk, mitigate the risk, and in the unfortunate instance where you do have an incident, how to investigate it, document it, to put your districts in the best possible position. So what we're going to do is we're going to talk about how we can protect students. I think everybody in here would agree that protection of students is the #1 priority above all else. And if we protect students, we have that corollary effect of mitigating or reducing the number of claims. We're going to talk about the reporting of claims and allegations, how to set up your district so that you can capture all of the relevant and necessary information so that you can conduct a proper and thorough investigation when allegations like this come to your office. We're going to talk about who and how to investigate allegations of sexual misconduct. Now, I'm going to use that term generically, but it's intended to include allegations of student-on-student sexual misconduct and staff-related misconduct, whether it's an incident on a school bus, whether it's in a classroom, in a after-school activity setting, doesn't matter. By the end of the presentation today, hopefully you'll have a good idea of the best practices and how you can take steps as risk managers to mitigate the risk to your district. We're going to talk about how to respond to the findings. I'm a lawyer, so I wouldn't be doing my job if I didn't terrify you with the potential financial impact on these claims. But I promise you, I've got like 2 lines in 1 slide. So it's not going to be a presentation on the law, but it is important to understand what the potential adverse consequences are and the adverse outcome is, which again is a good motivator for us to properly investigate and take action after the investigation. And at the end, we're going to talk about some real world examples. These are all cases that I've actually litigated either in a pre-suit process or in an actual lawsuit. They run from fairly innocuous to pretty egregious. And we'll talk about that. And my goal is to say, okay, this is the allegation that gave rise to the incident. This is the first piece of information that the school district became aware of. And then hopefully after the presentation, we'll round table and say, okay, well, what would you do with it? And then, of course, I'll let you know what the actual end of the investigation revealed. Again, could be innocuous, could be pretty gnarly, but we don't know if there's not a full investigation. So hopefully we'll talk about that. So, first thing we want to talk about is how to prevent child sexual abuse claims. We talked about, I'm going to emphasize this over and over again, protecting the students, identifying issues before they happen, or issues or circumstances that may result in abuse of a child, and taking risk mitigation steps to prevent that. And then once information becomes known that might be problematic and risk student safety, what to do with that information. And we want to talk about mitigating the significant exposure. A fully supported child sexual abuse claim by a staff member, for example, you can count on that being a 7-figure exposure. Easily 7-figure exposure. Now, a student-on-student might be a little bit less, depending on how the school district handled that issue. So you guys are thinking, well, David, what about the caps? Right? Caps of $200,000 per occurrence with a total of, $200,000 per person, a total of $300,000 per occurrence. Well, we fall into that trap. And we always look at the high end and we're like, okay, well, our worst exposure here is 200. And that's not necessarily the case. Because when we talk about the sovereign immunity caps, the way the sovereign immunity statute is written is it provides for the caps, 200 per person, 300 per occurrence. But that's what the definition is, per occurrence. So you have a hypothetical situation where you have a repeat offender. So if you have a bus aide, for example, this is a case that we actually did investigate. A bus aide gets arrested for 22 counts of either lewd and lascivious molestation or sexual battery on a bus. 22 counts on 22 different days. How many occurrences is that? 22. So we want to talk about caps. We got to look at the caps on a per occurrence basis. So in that particular case, every day that the claimant's lawyer, the plaintiff's lawyer could prove the sexual misconduct by a school board employee occurred is a separate occurrence. So we can say, yes, we've got the benefits of the caps, but we have to scrutinize that very carefully, because even with the benefits of the caps, 22 times 200 is not a small number. We talked about, when we talk about these cases, and that case in particular, the 22 occurrence case, we talked about the possibility of a claims bill. And what a claims bill is simply is if there's a final judgment that exceeds the sovereign immunity caps, a plaintiff that recovers that judgment can go to the Florida legislature and ask for approval to recover more than what the sovereign immunity caps provide for. So if there's a $2 million judgment and you pay the $200,000, or FSBIT pays the $200,000 as required by the sovereign immunity statute, they go to the legislature and get a claims bill. If you got a $2 million judgment, there's a $1.8 million unfunded judgment. And if the legislature says fund it, pay it, well, then it goes back down. And if your coverage all works out, you'll have about $800,000 left in your FSBIT, but then there's an extra $1 million. Where does that come from? If it's ordered by the legislature, it comes from your general revenue. And there's no district that I'm aware of that's got 7 figures of money sitting around that they can just pay out. So that's one of the other reasons why risk mitigation is of critical importance. And there's also some circumstances in legal theories where they can actually make a claim under the Substantive Due Process Clause of the United States Constitution, 14th Amendment claim. And that claim would require conduct that shocks the conscience. When we're talking about child sexual abuse by staff members, particularly against students, it's not too difficult to envision circumstances that might constitute conscience-shocking behavior. And those sovereign immunity caps only apply to state law claims, not to federal law claims. So there are no caps if a savvy plaintiff's lawyer decides to bring a constitutional claim against your school district. And that's the end of the law, right? Is everybody sufficiently scared? Okay, yes. All right, so how do we mitigate this? What steps do we take? And that is we adopt a comprehensive plan on how to address this. We want to define a culture within the school district that not only tolerates, encourages, and does not punish those that report suspicions of inappropriate conduct. Again, whether it's between student and student or staff and students. We develop written policies. And my recommendation is you have a policy that supplements your Title IX policy, which everybody obviously is aware of is required to have. Have a specific policy. We'll talk about details about that in a minute. And then we want to train on those policies so that everybody in your school district, from your student teacher to your administrators, knows what their obligations are if they receive information that could lead to an allegation of some kind of sexual impropriety involving a student. So before we talk about what best practices say and what my recommendation is that you do within your district, in my opinion, it's always important to use some good critical introspection, some self-analysis. So as you think about these topics, and as I go through this presentation, be thinking about what is your current culture within the district. If you have somebody that comes in and reports, man, I don't have any evidence at all, but Dave is really close to a 17-year-old high school senior. I don't know what it is. I can't put my finger on it. I haven't observed anything inappropriate, but it makes the hair stand up on the back of my neck. What do you do with that? Do you do anything with it? Just be thinking about how you guys as risk managers would handle those things. Think about Does that information even reach you currently? Or do your administrators address those kinds of issues on a case-by-case, school-by-school basis? And what is the accountability? If you have somebody that has an inappropriate relationship with a child, and I'm not even talking about getting into sexual impropriety, favoritism, they're transcending that line between educator and student, and they want to be friends with the students. There is a line there. What kind of accountability do you have to check those employees before it crosses the line into something more egregious? And then written policies. Do you have a written policy on how to handle allegations of inappropriate relationships between students or between staff and students? And if so, what does it entail? Do you have a singular point of contact, or is it up to the individual principal or assistant principal or dean of discipline? If two students are caught engaged in sexual conduct on campus, how do you treat that? What do you do? These are all things just to be thinking about as we go through the substantive part of the presentation. And again, I can't emphasize enough, I don't believe your current Title IX policies are inclusive enough. Title IX covers everything that it needs to. I'm suggesting that this is something that's separate and should be considered to be involved separately from your existing Title IX policy. Okay, let's get to it. Number one, see something, say something. Hear that all the time in any kind of context you can imagine, but here I think it's important. Staff, from the janitor all the way up, if there's something that doesn't look, sound, or feel right, encourage a culture of reporting. Because if it's nothing, an investigation will bear that out. If it's something, you can nip it in the bud early. We want protections for reporters. If somebody reports something because they have a bad feeling or they're suspicious, they shouldn't be penalized for reporting it, even if the investigation turns out to be nothing. I teach a lot of law enforcement as a former law enforcement officer, and we constantly preach we need to police our own. And I suggest that's the same thing for educators. The teachers that are across the hallway, the teachers that share the same students. If there's issues involving potential inappropriate relationships, whether or not it involves sexual conduct or not, it should be discussed, reported, and investigated. If something comes to the attention of district administration, it should be promptly investigated. We shouldn't wait 2 or 3 weeks to find out what we're going to do about it. I recommend when there's allegations of particularly sexual impropriety, this is a stop the presses moment. Because every day that lapses or passes from the date of the initial report could result in additional victimization. Particular case I had, not on a FSBIT insured, there was very strong suspicions based on some disclosures by a student that the stepfather was molesting a child. The principal called the student in, called the stepfather in, called the biological mother in, and they talked it out. And they came up with a written agreement that this 9-year-old girl would no longer walk from the bathroom to her bedroom wearing nothing but a towel. They didn't report it to DFS. They didn't do an investigation. They didn't report it to law enforcement. Of course, that doesn't involve a staff member, but the concept applies. They didn't take reasonable measures when they became aware of something, and unfortunately in that case, the worst thing happened. Weeks after that occurred, she disclosed to an after-school program provider who promptly notified law enforcement, and the investigation revealed that during that time period, after it was reported, after this meeting, where the child was counseled not to wear a towel in between the bathroom and the bedroom, she was being molested. I use that only for illustrative purposes. Factually, it doesn't fit here. It's not a staff member, but the importance applies. We want to take prompt action because we do not know what is happening until we investigate. We need to be consistent between those who report and those who are accused. We've learned these rules in the Title VII employment discrimination context. Oh, that's just Dave. He's touchy-feely. Well, no, if he's putting his hands on the shoulders of female students or female employees, it doesn't matter if he's just a friendly guy. We don't do that. And staff members need to be coached or counseled. If we've got students that are acting inappropriately, PDA, outside of the rules and regulations of your district and school, promptly resolve it. Because if two children consensually engage in sexual conduct on school property, what kind of claim are we looking at? Negligent supervision. We didn't properly supervise these children. And depending on the age of the children, could be really problematic. And then, of course, once the investigation is resolved, need to promptly address it. And by promptly addressing it, that includes looking at prior documentation of in my example, the staff member that was engaged in misconduct. We don't say, okay, well, 4 years ago, this administrator, this teacher, was counseled for using sexually explicit language in front of a child, commenting how a female student looked in a particular sweater. But that was 4 years ago, so we're not going to include that in our evaluation of misconduct for these sustained allegations. Not all offenses are created the same. And we'll talk about some different kinds of sustained violations, again, student or staff, and what are the possible ramifications. But we need to be consistent across the board. Similar conduct, similar sustained conduct, that is proof that it occurred, should be handled similarly amongst other students and staff members. And then, of course, we always, always, always want to remember our obligation to call the DCF hotline. It is a felony if you have knowledge and do not. And if two teachers are in a room and they both have information that warrants a report, teacher A thinks teacher B is going to do it, teacher B thinks teacher A is going to do it, guess who is potentially going to get arrested? Both of them. I've defended school boards in cases where teachers have been arrested for failing to report to DCF a reportable offense. So this is the culture, this is the umbrella under which that I recommend that we look at our districts, evaluate how we can do better in consolidating this information, coordinating this information, investigating it, and then taking action. We already talked about supplementation of the Title IX policy. I recommend a centralized repository. And that means every single one of the school board employees should be trained that if there is any suspicion of inappropriate relationship or sexual misconduct, that it needs to be reported to district headquarters. Why? For consistency. You as risk managers or your staff or people at the headquarters level can treat every allegation in the district the same, versus principal 1, 2, and 3 may have different subjective beliefs or feelings about how these kind of things should be treated, may investigate them differently, may document them differently. Consistently is your best weapon to prevent or mitigate legal exposure and risk. And what is the threshold of the obligation to report? How do we write that down in a policy? How do we train on that? I take a very expansive view. And when we talk about real-world examples, you'll understand why. If it doesn't look right, it doesn't sound right, it doesn't feel right, report it. There's no stigma in being investigated and conclusively cleared of any misconduct. Would you rather your district have a very proactive reporting procedure and policy? A very proactive investigative procedure and policy? Or do we want there to be the continued risk and exposure, again, protecting students, for not reporting something? Gosh, there was just something about how he treated this student, or how this male teacher looked at these female students, or this female teacher dealt with these 15-year-old student athletes. Just something wasn't right, but I didn't think about reporting it. That's what we need to combat. Any allegation, regardless of against whom it is made or what the content of the allegation is, should be investigated. You will never, ever be criticized in a court of law or by any of your defense counsel for conducting a thorough investigation. Because investigations are a two-way street. We don't investigate to find misconduct. We investigate to find the facts and let the chips fall where they may. And a proper investigation that clears the employee helps not only the district, but the employee. And we'll talk about the different ways to categorize the conclusion of your investigation in a minute. You need to identify who will investigate. Do you have anybody on staff that is competent and qualified to conduct an investigation involving these kind of difficult issues? And what reports are going to be completed? Again, the goal is consistency, so that every allegation in the district is treated the same, rather than different administrators at different work sites treating them differently. And then, of course, we want to talk about discipline and remedial training. And I use remedial training because not all inappropriate conduct warrants discipline. If you have that teacher that's not done anything illegal, not done anything improper, not done anything that violates your policy, but they're overly familiar with the student, and it gives rise to, we use the word phrase, bad optics. It just doesn't look right, even though it's not inappropriate or improper. There's absolutely nothing wrong with pulling that employee aside or giving them a counseling and say, you need to pay more attention to that line between educator and student. You're not their friend. This is particularly an issue in high schools where we have student teachers or young teachers that may only be 3, 4, 5 years apart in age from their students. If you have a 17 or 18-year-old senior in high school and a 22-year-old student teacher, those issues are a lot more gray than the scary examples of a preteen and a grown adult. And there are sample policies out there. I don't write policies, but we can get them from other districts. We can work through those. You can get legal staff to review them and to assist you, again, in defining that culture and serving as a basis for your training of all your staff. You can't judge a book by its cover. Every single one of these people has been convicted of or accused of some kind of sexual offense involving a minor. If you saw them in the street, if you saw them on the playground, if you saw them in the administrative office, can you tell who's the bad guy? Nope. A little bit dramatic, but anybody that's sleeping after lunch. But the point is that we can't say, well, I've known Dave Marcy for a decade, and there's no way David would do that. That may very well be true. But can you really know somebody? How many times have you seen on the news the neighbor that gets interviewed? They find the guy that's cutting people up and eating them in the basement. Well, golly, Dave was a great guy. I would have never guessed that. Student protection, number one priority. Risk mitigation, secondary. Very important that we pay attention to the facts and the allegations, not how well we know somebody, what they look like, because we don't know what child molesters look like. We can all foster an image of what we think is the case, but the most successful don't look like the creepy guy driving a panel van with free candy on the side of it. They're men and women that look like our neighbors and people we work with. Similarly with children. Obviously, I'm not going to post a bunch of kids' pictures up there. It's the same thing. We are seeing sexual predators as early as teens and preteens. We need to be aware of it, and we need to keep our eyes open. Okay, investigation. What are we going to do? Again, I already talked about this. I recommend a district-level investigation for consistency and transparency. So every allegation in your district is treated the same. Also, thoroughness. Because if you have one person or a small group of people that's conducting the investigation, it's easier to train them, it's easier for them to develop experience, and it's easier for them, in conjunction with risk manager, school board counsel, or outside counsel, to be able to develop the skills necessary to not only identify issues, to investigate them, and then how do we report it. The investigations must be neutral. We are not out to rake anybody over the coals, regardless of how egregious the allegations are, because they're allegations until they're proven. We must constantly strive to approach every allegation with or every investigation, with neutrality, regardless of how egregious the misconduct. Because we want everybody to be treated fairly, because not everybody that you investigate will have engaged in inappropriate conduct or inappropriate sexual misconduct. Because a good investigation, a thorough investigation, a neutral investigation will clear employees that did not engage in inappropriate conduct. That's why we focus on neutrality. We're investigating the facts. We will draw our conclusions from the facts. We are not investigating an outcome. And checking the boxes, and we see these all the time. I see them in litigation cases. Did you do investigation? Absolutely. Well, what'd you do? Well, we filled out an incident report. Okay, well, let me see it. Check, check, check. Student injured, right arm, fell off swing set. That's your investigation. Yep, that's it. Is that going to be beneficial in an allegation of inappropriate conduct or inappropriate sexual misconduct? It's not. Probably not real helpful in falling off a swing set case. But on these kind of egregious cases or these egregious allegations, it's even more important that we do a full-blown investigation with an attention to the facts, the details, rather than just saying, I've done an investigation. Who should investigate? Do you have somebody right now within your district that you would trust to investigate an allegation of inappropriate conduct or inappropriate sexual misconduct between two students or a staff member and a student? Internal investigations means somebody within the organization to do the investigation. Anybody have any comments on that? What kind of cases you think should be investigated by somebody within the school district? I'm thinking the more minor allegations. So-and-so is alleged to have shown this student an inappropriate picture. All right. Let's investigate. Could be nothing. Could be something. And if your nothing investigation or your minor allegation turns into something more significant, well, then you can always advance to the next level and go outside the agency. Your city attorney, your school board attorney is probably going to be your best source for making or assisting in the decision, do we want to hire outside counsel to come in and do an investigation? I do many of these because of my background. If you get a 768-28 notice letter, a notice of claim letter, where there's an allegation of some kind of impropriety, either the district tolerating sexual impropriety between students or, more egregiously, a staff member engaging in sexual misconduct, make sure you promptly send those to FSBIT. Because there are, not all of them, but there are some times where a pre-suit investigation is warranted on very significant and serious allegations. And you may have coverage for that. Depends on a fact-by-fact circumstance. I don't make those decisions. FSBIT does. but you at least want to pass it along and discuss that. The more egregious investigations, allegations, I strongly recommend be investigated outside. There's an allegation of improper touching, sexual contact, things like that. Really need to think about going outside and retaining counsel or an outside investigator to make a factual determination, to present those facts to the risk manager so that your administration can determine what follow-up treatment, discipline, or remedial training is warranted depending on what the sustained allegations or sustained findings are. If in doubt, call your school board lawyer. These are so many legal minefields here, and I hate to use the phrase CYA, but please CYA. If your city attorney, excuse me, I just taught a class with municipal police officers, so excuse me if I keep saying city. But if your board attorney says, oh, no, we got to get somebody, probably means you need to get them. And if they say, we can investigate it internally, I'm not saying you shouldn't, but you want to include legal in that analysis to assist in making that decision, particularly if there's not a lot of experience in your office working these kinds of investigations and cases. Again, please, it's in here twice for a reason. It's never fun for me to get a phone call that an educator's been arrested because they did not comply with their DCF reporting requirement. Okay, we want to start timely. We talked about that before. Don't wait 3 weeks. And if you've never had one of these, the time to decide how you're going to handle one of these is not when you get the complaint. That's why I recommend evaluating your culture, evaluating your policies, come up with a plan so that if you get one of these allegations, you can immediately start investigating it. And you don't lose valuable time trying to determine how you're going to investigate. If you have the process, you have the policy, you have the procedure in place, you just whip out that policy manual, that procedure, and you implement what you put together before you're dealing with the stress, maybe public scrutiny. We've all seen things in the newspaper, parents' phone calls. Much better to develop your plan before you're dealing with all of those extrinsic stressors. Consider temporary remedial measures. You can relieve an employee of duty. You can reassign them to a position that does not involve student contact. It all depends on the seriousness of the allegation. If there's an allegation that a teacher is having inappropriate sexual contact with a child, I suspect they should be suspended with pay pending adjudication. If the allegation is, hey, you look really nice today, well, does that need to be looked at? Of course it does. Is it objectively problematic? It could be. That may not warrant suspending somebody. You may want to reassign them to an administrative position. Because what's that investigation going to entail? How long can you do an investigation of an employee that says, hey, you look nice today? That's a 2-day investigation at most. Things to think about. Again, protection of students is number one. Same thing with student on students. You got an allegation that there's a student that is acting inappropriately or acting out sexually, you need to remove that student from the classroom. I'm not talking about suspending them. Nothing been proven yet. Need to take steps to separate the alleged offender during the period of the investigation so you can determine whether or not the allegations are true and whether or not if they violate any rule or student handbook violation. You want to understand what occurred? Contact others. What does that mean? Well, if you've got Dave Marcy, who's a student that's acting out inappropriate in a sexual manner in Ms. Johnson's class, well, don't just talk to Ms. Johnson, talk to all the teachers. If you've seen anything similar, reach out to your council. If you have an employee in your district that's worked these cases before, reach out and talk to them. You want to conclude the investigation as quickly as possible, again, because allegations can stain an innocent person, student or staff member, and if the allegations are sustained, found to have taken place, we need to take prompt action. and we want to prepare a report, a real report, a summary of what people said and a summary of what the conclusions are, not a check block. Policies in your CBA always guide what you do. You can't just change your CBA. There's probably nothing in here that I've talked about that would impact your CBA. So really policy development. We talked about having a separate policy versus Title IX. Have a good policy, and then when you implement it, follow it. Again, consistency is the key. Protecting the innocent, accused, students and staff, and creating a defensible procedure that if the violations are sustained and you have to take some kind of adverse consequence, suspension or expulsion, or termination of employment. Notify everybody that you need to notify, including parents. And I can't emphasize this enough. Take all allegations seriously, as innocuous as they may sound. And I've got some examples at the end that will illustrate that quite nicely. Take a look at your policies. Take a look at the code of conduct, particularly if you haven't reviewed it in a while, to see what the standards are that you're investigating. Anytime you remotely get wind that there is a potential criminal investigation, you immediately call law enforcement. Doesn't matter where you are in your investigation, doesn't matter who you've talked to, doesn't matter who is left to be talked to, promptly, and by promptly I mean that same day, notify law enforcement. And we do not investigate crimes. You as risk managers, me as a lawyer, anybody that does not have a badge should not be investigating crimes. Why? One, we're not qualified to. Two, we don't want to interfere with a viable or valid criminal investigation. We don't want to, through the best of intentions, to inadvertently complicate or create problems if the law enforcement agency ultimately comes in and does conduct a criminal violation. None of us wants to be that mistake that allows somebody who is engaged in misconduct, particularly kind of the egregious misconduct we're talking about here, to let them avoid responsibility in a criminal court system based on our investigation. Okay, what are we going to collect? Transitory evidence. Transitory is a fancy way of saying anything that can be lost. Photographs, emails, Facebook posts, anything you can grab. We want to interview everybody that might have knowledge. Under the new tort reform, people have 2 years to report torts, negligent supervision, and the like. Constitutional claim is 4 years. So can you think back 3 or 4 years about what you did on a given day when presented with an issue that came up at work? Probably not. I can't. I can't tell you what I had for breakfast 3 days ago. So it's important to do the interviews and lock down that information during the preliminary investigation. Identify all witnesses. Talk to all witnesses. Write down what they told you. Memorialize what they know. They should be in person for something as egregious as what the topic areas we're talking about. You should ask them to maintain confidentiality, but you can't require it. Why? We don't want one witness talking to another witness, and then we have the telephone game effect. We want to get the information from the source. We want to get the information from the witnesses based on their own personal knowledge, not what they heard through the grapevine. The basics. Who, what, where, when, why. Who else has information? Have you talked to anybody else that has knowledge about these allegations about the relationship between student A and student B, or staff member A and student B? Dates and times are important. Remember what I said earlier about the per occurrence. If things happen if 3 different acts occur during the same encounter, that's one occurrence. Not to be graphic, but if there's oral sexual contact and intercourse in the same instance, that's one occurrence. If they happen on 2 different days, 2 occurrences. Significantly and dramatically impacts the district's exposure. So we want to document it during our investigation. Is there anybody else out there we need to protect? Anybody else that's been a victim of a predatory student or predatory staff member that we need to take steps, whether it's temporary steps to remove them from a circumstance where they can be abused, or whether it's more permanent steps, and say, okay, well, now we have 3 different instances where this student or this staff member offended, which certainly aggravates the potential outcome. More is better. You as risk managers are governors of information. You collect it. Sometimes you sit on it. Sometimes you immediately send it to council or FSBIT. But if you have already gathered it, you have already put it together, that will help you significantly if and when a lawsuit or notice of claim letter is filed. You don't have to go back after the fact 2 years later and try to recreate something if there was a prompt investigation that was done timely. All right, let's talk about reports. I alluded to this before. You know, the form incident report is the pre-printed thing. Was the student injured? Yes. Where? Right arm. What was the location? Playground. What happened? Student fell off jungle gym. That's an incident report. An investigative report is, I received information that student A had acted in a sexually aggressive manner against student B. I undertook an investigation. I spoke to these 3 people. Person 1 told me this, 2 told me this, 3 told me this. There was no physical evidence. After a careful analysis and evaluation of the witness testimony, I find it more likely than not there was a violation of the student handbook or there was not, as opposed to that check block. Now, these investigative reports are usually confidential, and I say usually because in law nothing is definitive. What do they say? Nothing in life is definitive except death and taxes. In our world, in the litigation world, there's several cases that are very strong. Matter of fact, we just won an oral argument on this earlier this week, where a plaintiff has tried to get our investigative report. Not ours as the lawyer, but the district's. Nope. Here's the case. It's confidential. Judge agreed. I've never lost that argument, but it's theoretically possible. So we generally, as a rule, don't have to worry about, well, I interviewed Dave Marcy, and he gave some inconsistent statements. He said this, and then he said this. We don't have to worry about that. Because almost always, it's privileged and confidential. We don't have to disclose it. Fully identify all witnesses. You may know who, I'm sorry, go ahead. No. What the investigative report, what that privilege is facts that were uncovered during the investigation and opinions that were made during the investigation. So if there's a handful of documents that are out there that were evaluated as part of the investigation, those may become public. Just not the report that contains a summary of your facts and your conclusions based on your investigation. But excellent question. We're going to fully identify the witnesses. You may know who Ms. Smith is at a certain school. I don't. Your litigation lawyer won't. You may have multiple Smiths in the school district. So please just use a first and last name. It'll help us significantly in identifying witnesses if we get involved, or somebody like us, another one of your litigation attorneys. Identify everything that was collected. Please preserve videos. We've had several cases here lately where we do our follow-up. Once it becomes litigation, we call the witness. They're like, yeah, I watched the video. Did you save it? No. Okay, well, not only can we not use it, we might end up getting in trouble with the court for not preserving. So preserve everything. Interview summaries I talked about as part of the report. I talked to Dave Marcy. He said this. He saw this. He heard this. Include all the facts that you think are important. And then if there's violations, identify them. Student handbook, district policies. That's what the purpose of an investigation is. To determine if a student or staff member violated a policy or procedure of the school district. What we don't want you to do is put in your opinions. Just the facts. Joe Friday. David said this, then David said that. And they're different. Don't write, I think David's a liar because he couldn't tell the same story twice. Just avoid editorializing in an investigative report. All right, misconduct findings. What's the standard? Okay, you've investigated it, you got an allegation, you reported it, or it was reported to you, you investigated it, you determined who was going to investigate it. Now what do you do with that information? You've evaluated the policies and regulations to see if there's a violation. Now what do you do? Is there reasonable cause to support a finding, policy, or rule violation? What is reasonable cause? Can you articulate specific facts that were uncovered during your investigation that constitute a violation of policy or regulation? If you can, then there's reasonable cause. You look at the totality of circumstances. That's a combination of all witnesses and exhibits. If you have 5 people that say one thing and one person that says something different, how do you weigh that information? You do just like a police officer does, just like an internal investigator does, just like I would do if I investigated it. What's more credible? What's more likely to be true? This same fact that 5 people agree on, or the one person account that's disputed by 5 people? Oftentimes they're not that clear cut, but that's illustrated. And that's the standard. Can you articulate facts or circumstances? Why? What did the student or teacher under investigation do factually? Not what you think, not what you suspect, not what somebody else thinks or suspects. Factually, what has been uncovered, and does that constitute a violation? You must make credibility determinations. Sometimes you can't. 2 people are in a room, 2 students in a room, they have a fist fight. They come out, student A says he started it, student B says he started it. How are you going to prove that? You can't. Sometimes it's okay to say unable to determine due to conflicting information. But you have to use your common sense. Can you articulate why one account is more reasonable, more accurate, more believable than the other? Use my 5-on-1 example. Because that's what police officers do. You're not judging, you're not the jury, you're not the arbiter of truth. You're simply making a determination, this account is more credible than this account. That's all you're doing. Findings, what do you say? Okay, so I've investigated it. There is articulable reasons to say David violated this policy. How do I write that down? How do I memorialize that? And best practices in conducting internal investigations provide a couple or several actually outcomes. Sustained means that there's reasonable cause to believe the allegations alleged were true and that there was a violation of policy or regulation. Not sustained simply means there's insufficient evidence to establish. Use my fist fight example. I don't know whether student A or student B started the fist fight. So that would be not sustained. We know a fist fight occurred. We know that they engaged in a fight. You just can't determine who started it. Unfounded means exactly that. It did not occur. The allegation that initiated the investigation factually did not occur, is unfounded, and exonerated means the allegation that initiated the investigation occurred, but did not violate any policy or regulation. And of course, for employees, report to PPS if necessary. We've already talked about reporting to DCF for students. Okay, I lied earlier. I forgot this slide was in there about the law. In the unlikely event that the report does become discoverable in litigation, we don't ever want any internal investigation, whether you do it or I do it, to say the school board was negligent. That's a legal conclusion. It's not a fact. There are arguments that if you create an official record in your old risk manager and the very rare circumstance comes up where it's disclosed or discoverable, they can say, hey, look, the board admitted they were negligent because the risk manager did an investigation and said it was. And we don't want that to be used against us in litigation. Again, factual summary, Joe Friday, this is more credible than that, sustained, not sustained, exonerated, or unfounded. All right, corrective action. We're almost to the scenarios. Protection of the students. There's a common theme here. We should consider the severity of the sustained findings. Did David make a comment to a student that says, oh, you look nice today? Or was that coupled with, you look nice today, rubbing a hand up and down the child's back or otherwise touching them? Facts are very critical and important. That's why we want such a detailed investigative report. We want to consider the severity of the sustained finding, the history of the student or employee. We do that all the time in student discipline. What's the disciplinary history look like? Because somebody that's been in trouble all year, has got multiple referrals, is probably going to be treated different than somebody that's a senior in high school, never been written up. We're going to do the same thing with employees. We want to define the culture and send a message. We will not tolerate this kind of behavior. It's up to you to define what that is. Low on the threshold, behind kind of doing the right thing, is liability. What are we looking at here? Are we going to get sued? Could we get sued? If we do, is my investigation thorough? Does it provide enough information so whoever's retained to represent us in negligent supervision of a child case or negligent supervision of an employee case, have we done enough work to give them the tools that they need to defend the school district? I'm talking about sustained findings here. I'm not talking about the innocent person. That's why you call them an offender. How much should we care about the person who has sustained findings for sexual misconduct on a child? I don't know. That's an individual decision. Me, I don't have a darn bit of concern. They made their bed. Again, I'm talking sustained findings, proven findings of people that engage in this kind of egregious misconduct. Just to be clear, I'm not talking about the innocuous allegation or the investigation that sustained something minor or non-sexual. What we don't want to do is give these people a pass. In my opinion, if there's sustained findings of sexual impropriety, that's not a resign or be fired circumstance. Up to your own division or your own district preferences under the guidance from your superintendents and your board attorneys. My advice is always, if you have sustained findings of these egregious violations, don't give them a chance to resign. Because what happens if the PPS stuff falls through? And the next district picks them up. Just got to be careful about that. All right, student stuff. We're not really here emphasizing students. Everybody here is familiar with the process. But we want to just follow your policies. You've got sustained violations against a student. We want to, again, treat them based on the severity and handle it the same way you do other stuff. All right. This is the fun part. You get a call on the phone. One of your teachers reports, hey, Dave Marcy is coach of the girls volleyball team. He's spending a lot of time with this 17-year-old female student. I haven't seen anything. I haven't heard anything. Haven't heard any rumors. Just makes the hair on the back of my neck stand up. What do? This is the participation part, so. We're almost done. You almost get rid of me. But so what do? You get that call. You're sitting there at your desk. You say, okay, appreciate the information. You hang up the phone. How do you handle that? Anybody? You investigate it. With what you know now, after my very eloquent presentation, what do? Do you investigate that? You're shaking your head yes, sir. What do? Oh, okay, excellent. And did it turn out to be something? Very good. And my example didn't have anything to do with him. I'm hearing this the first time. And that is it. Right? Well, and that is an excellent counterpoint to my personal experience with this one. What this one turned out to be was the exact opposite. An investigation took place. They found out that the volleyball coach was having intercourse with the student in his office. Not he said, she said. They called law enforcement. Why? Because we don't investigate crimes. Clearly, that would be a crime. They found biological material in the office consistent with sexual intercourse. We'll just put it that way without being too graphic. Of course, he gets arrested and goes to prison. But somebody had to make that decision when they get this innocuous phone call. Because, hey, golly, I think Coach whatever, he seems to be given preferential treatment to this student. And this is a great example. Two opposite ends of the spectrum. One real-world example where you could pull that employee aside and go, hey, look, this is the perception. You need to be conscious of the perception because sometimes it's the perception or appearance of impropriety that's problematic, even if there's no improper conduct. Or it could be the most egregious, which is a circumstance that I had, actually litigated that case. Paid out a lot of money on that one. Of course, in my example, the guy went to prison. They had the biological material. There was no wiggle room at all to say it didn't happen. Okay, here's another one. Male bus aide pays particularly close attention to a 15-year-old developmentally challenged female student. When I say always sits next to, of course, buses have video. Every time this student got on the bus, this bus aide, 70 plus years old, would go and sit usually across the aisle on the school bus. The bus driver reports it and says, hair on the back of my neck, something is wrong. What do? Everybody now knows to investigate. If somebody says, oh, I'm not going to investigate it, I'm just going to put the mic down and walk out. We're going to investigate it. We're going to investigate it. Why? Because it could be nothing or it could be the most egregious. So what happened? So the recipient of the complaint did nothing. Time goes on. The bus aide comes up to the bus driver and says, oh, I bought so-and-so a necklace or a bracelet. What do you think about this? It's her birthday, I think it was. I think you shouldn't be giving a present to a student. No, you shouldn't do that. It's inappropriate. Whatever, grumbles, walks away. They're in between schools at a pickup. Bus driver is off excuse me, the bus aide is off having a smoke or something. Bus driver walks back, looks, opens up this box, and it's a bracelet. So concern gets amplified when the student walks off the bus wearing that bracelet. Reports it again. Different administrators get involved. They go back and they review the video. And what the video shows is while they're across from each other on the aisle, the bus aide is constantly reaching over into the student seat area. Now you can't see what's happening, certainly causes some suspicion. Report it to law enforcement, they investigate it, they arrest the guy, and charge him with, I want to say it was 22 counts, that's the example I used earlier, of either lewd and lascivious molestation, which is touching the buttocks or genitals over the clothing, or sexual battery, which would be digital penetration. 22 counts. Over 22 days, 22 occurrences. We were very lucky in that the second group of administrators that found it did a good job. They did a great job. The failure was the recipient of that first complaint that did nothing. And from that day forward, my analysis was if we were to go to trial, the district would be responsible for every single day of abuse because the first recipient of that complaint didn't do anything. Most egregious circumstances. We were able to get that case resolved within policy limits without having to go through a lawsuit. Okay. Here's one. Got a 13-year-old male student sitting with a 6-year-old female student. To set this one up, policy says the bus is divided by age, older kids in the back, younger kids in the front, not enforced. The bus driver, when the bus is loading at the school, is standing next to the bus driver's seat as kids are coming in. They're loading in. She's on her phone. The 13-year-old is like 2 seats back on the left side of the bus if you're looking backwards. The 6-year-old student walks by him on video. He reaches over, grabs her, puts her in the seat next to him. Bus driver's on the phone, just playing. The 13-year-old takes his jacket and puts a tent over him and the 6-year-old. And the worst thing happens. There's sexual molestation. While the bus driver is 2 seats away on the phone like this, while he's covered up the 6-year-old child. That one was investigated very thoroughly, and they did a good job. We were able to prevent additional victimization. But we've talked about, and the reason why I include this one, we've talked about what do we do to the offender, right? What do we do to the employee that does something wrong and has an inappropriate relationship? I include this one because should an investigation be opened into the employee that did commit any sexual impropriety but was not supervising the students? Literally, and I didn't mean to invade your personal space, but it was literally 2 seats away on video. Very, very, very difficult to defend. Very, very significant exposure. Okay, last one. The allegation comes to administration. Teacher Dave Marcy showed me a sexually explicit photograph. 16-year-old female student. So they investigate it, look into it. Really inconclusive. Law enforcement's looking at it too. And I didn't really get into how do you do an investigation when law enforcement's also looking at it. That's beyond the scope of what we're talking about here today. But the district delayed in reaching a conclusion because they were waiting on law enforcement. If you ever have a case where law enforcement is investigating something you're also investigating, call your board attorney. That requires an attorney to assist you in guiding through that process. Again, why? We don't want to interfere with a criminal investigation. But in this case, we got this very serious allegation. Adult male teacher showing a sexually explicit photograph. Lawsuit is filed. My law firm defends it. And there were some inconsistencies in the complaint. Well, what does sexually explicit mean? We don't know. They didn't tell us in the complaint. So during the discovery process, everybody's familiar with discovery, right? Where we send interrogatories and requests for production and things like that to get information. Okay, you've made these allegations in a lawsuit, which is literally lawyer words on paper. What's your evidence? And they hemmed and hawed, and they wouldn't respond. So we moved to compel. We press, we press, we press. We get some back channel information that the sexually explicit photograph was a picture of the teacher at a public pool with his puppy. Well, we get that. Well, could it be inappropriate? Yeah, it could be. Is it sexually explicit? Not from the sounds of it. So we do additional targeted discovery. They wouldn't respond. Identify specifically, what was in the photograph that constitutes sexually explicit as defined in paragraph whatever of your complaint. They refuse to respond. Turns out the photograph was exactly as it was represented to us. It's a guy at a public pool, fully clothed. Well, had a bathing suit on, no shirt. The only bit of skin you could see is like this much of his shoulder because he's got this big dog on his chest. But there was a lawyer that was willing to sue over that. And once we got into it, we're like, okay, well, the teacher didn't do anything wrong. And it was, again, context is important. It wasn't, hey, take a look at this. It was just showing pictures. That the photograph was most clearly of the dog. You literally could see like a little bit of shoulder. And how that got to sexually explicit, beyond me. But it's an example how sometimes an innocuous allegation turns into something egregious. Sometimes an egregious allegation turns into something innocuous. So, just a little lesson learned, real life examples. Here's my contact information. Fisbit can get you the slides if you found any of this helpful. And then I'll let CJ come up and talk to you about a new benefit that you're going to get as a member of Fisbit.
Thank you, Dave. So we already, when we have a claim made, a lot of times we'll discuss, I'll discuss it with the district and we'll decide, is this something we want to hire an attorney pre-suit for? Dave does that quite often for us, especially for these sexual abuse cases. But what we're going to offer now is when an incident is not yet a claim, and let's say, like Dave was, someone says, I don't like, this teacher's spending too much time with this student or the coach. We're offering a 30-minute consultation for you to call Dave, discuss what you know about the claim, and let him give you feedback, let you know if, where to start in your investigation if you're not sure. And he'll tell you what documents are needed and immediate actions, because it's very often that we're coming in, and a lot of times you guys don't know until something terrible's happened. So we want to offer that so that hopefully we can get ahead of these types of claims and not be playing catch up at the end. So, and of course, Dave is very involved in our litigated matters and represents us in those. And we've unfortunately had several of those together. So,
And you're welcome to give this to your HR director or whoever typically is doing those investigations. They can call Dave directly. They don't have to wait to connect with you. You can offer that, resource up to them, and they can utilize that service however they feel is appropriate in line with sexual, physical abuse concerns or questions that come up.
yeah. And that the phone number that's on this slide is the number to call to reach Dave. Does anybody have any questions for Dave?
I just wanted to add is typically how this works, and I've done this successfully for over a decade with Florida police chiefs on police matters, is if you get that phone call and you're sitting there and you're vapor locked a little bit, well, what do we do now? Call me. The number that's on there is my direct number. If I'm in the office, it rings at my desk. If I'm on the road like now, it rings on my cell phone. Or you can email me, and then we'll connect. And I'll give you recommendations. Again, I'm not trying to supersede your board lawyer. My role is to supplement your board lawyer. So feel free to include your lawyer in any discussions or conversations that we have. The goal is to say, okay, look, here's the benefit of my 30-some years of working these cases. This is what I recommend your next steps be. And that is just part of your membership benefits with FSBIT. This is the only school board insurance company that I'm aware of, and we work for others, and I'm aware of even more, that offers this benefit. So call me if you need me. I'll be happy to help you. I think Pam, when she was risk manager over in Santa Rosa, I'm very reachable. My goal is to return calls by the end of the day unless I'm in trial. So it's not one of those circumstances where you'll call me on Monday and you might hear from me by Friday. Particularly these cases, because they are so critical and time important. So please call me if I can be helpful to you.
If you do not have someone who does the investigation process, then that's another option that Dave is available to go direct with you. Lori and them, as I mentioned the other day, utilized Dave to do the investigation on the burn situation with the CTE program. So, engage and let us offer that support as needed when you have those really tough situations.
Yes, exactly. And just to spin off of what Pam said, is that first consultation is on FSBIT's dime. That's part of your member benefits. But if you wanted to engage me individually, your district can hire me to come in and do the investigation. If not do the investigation, can assist in guiding the investigation beyond your initial consultation. And I do that with many, many school boards. I do it with police departments and law enforcement stuff, police shootings and serious things like that. It just gives some additional benefits for y'all to have somebody with some subject matter expertise that your school board may not have. But again, I cannot emphasize enough, I work in conjunction with, I do not want to be a school board lawyer. This is not a pitch to be your school board lawyer. So I really encourage y'all to include them in our discussions so that we can make the best possible decisions for the district.
The nice thing is we have the opportunity then to then have Dave handle the case if it goes to a claim. So rolling it right in keeps that consistency, and he has that knowledge, intimate knowledge of the case and the investigation details. And again, if needed, and if you do not have someone serving in that role currently. Thank you, Dave.
All right, if anybody has any questions, just reach out to me.
Thank you so much. Hold on. Yeah, so I've got three things here that we need to do before our final activity, and the first one is we want to recognize Bart for the great job that he has done for us. So put your hands together. Bart, thank you so much for the past year and the many years that you have devoted to. Put it this way, that way you won't be in the light. The many years that you have devoted to FSBIT, and we know that you're going on to. I won't put it as David did to be a competitor. We look as maybe a future partner. So we thank you for everything that you've done, and congratulations on your new job.
Thank you.
Yep. Okay, in the back of the room are signups for dinner tonight. So if you don't mind, before you leave here, so that if we need to make reservations and have a few more going to one or the other, we can notify the restaurants as to who they can be expected. And the next thing is, Pam told me that I was getting well known for being the photographer. I really don't like that part, but we're going to take another picture anyway. So we would like to do a group photo. So if you guys would all maybe come over there, we'll take a group photo. And then we have one final activity that I promise you will not take very long at all. But that is a reflection activity on what you're going to do next, giving the information that you have, or maybe some objectives that you have for yourself. So let's all meet over here in front of the doors, and we'll take a photo, and then we'll go right into the activity, and then we'll get you released and out of here. I am going to say by 3 o'clock. Okay, so before you go away here, we've got one final activity for you to do. But given that we just recognized Bart for his exit, we need to select a individual who is going to be the risk manager trustee. So according to our trust document, it does say in there that we have another committee called the Executive Committee, and the powers that are vested within that Executive Committee are to make certain decisions on behalf of the group that are later presented to the trustees. So there is a rule out there that says that no county can have more than one vote on the Executive Committee. So the Executive Committee currently consists of Bev Slough as our chair, Wendy Atkinson as our vice chair, the risk manager trustee, which would be the position that we are electing. The FSBA chief executive officer serves as the treasurer, and then we have our superintendent trustee, that is currently Robbie Edwards. So as we look and select our risk manager trustee, in order to avoid two votes on there, unfortunately, Jocelyn, Gerald, and Amanda are not able to be considered as it is right now as the risk manager trustee. So I would be happy to entertain a motion, or if anyone would like to campaign on behalf of somebody else or themselves to be the risk manager trustee, now would be the time to do so.
I'd
Amanda.
like to nominate Alexandra.
Alexandra, do you accept the nomination? Yes. Okay. So we Ish.
Do we need a second?
So we have a nomination.
I'll
Would you
second
like to
her.
make that second? Okay, so a second by Sarah. So are there any other nominations for risk manager trustee? Okay, so seeing none, we'll proceed to vote. All in favor of Alexandra as the risk manager trustee, say heck yes.
Heck yeah.
All right. Anybody opposed, say no. Okay. All right. Congratulations. All right. Okay. So again, real quickly. So if you look up here at the screen, you're going to see the district success planning instrument or the tool. And we're not going to ask you to turn this in. That is, this is a tool that is strictly for you to reflect on some things that you might want to consider in the future. And so this may be something that you've been thinking about that you always wanted to do. It may be something that over the last couple of days may have piqued your interest that you really want to go back and check on. It could be something related to a vision that you have for your school district. So if you look at this, the program or department, boy, that's a comprehensive list. I mean, there is everything but the kitchen sink is on there. So it's doubtful that you are going to be able to make that the primary, every one of those, the primary focus of your work that is going forward. But what we would like for you to do is pick up the highlights. If there is something that you recognize that you probably want to focus a little bit more attention on, so we'd like for you to star that. We also want you to know that if there are any things in here that we can be of assistance to you on, and or needs to be topics for future meetings that we can help gather information on, if it happens to be policy related. I like that there's a lot of exchange going back and forth about, hey, fellow risk managers, do you have any information on this? We have lots of good things that are happening in each one of our districts, and I think that you can highlight some very positive things that could be shared with others. So what we're asking you to do is if you just want to go down the left-hand side of that list, it's two-sided so that you can go to the back as well and look to see if there's anything that resonates with you that you would like to champion or you would like to make a priority for you, yourself, or your district. We would like for you to mark those boxes off and make a few notes for yourself. And then I'll give you about 5 minutes to do that, and then we might have a couple share-outs of some ideas, and then we will wrap up our summer session. Okay. All right. So I see some people still writing, so that's great. You're putting some thought into it. What I would like to do, you can continue writing, but if we could get two people to share out maybe a goal that they have set for themselves for this next year, we will wrap it up. So who wants to be the one of the volunteers? Thank you, Sarah.
Hear me? I really want to look into the fire and life safety inspections, particularly concerning the CTE safety, because I didn't know that was something we need to be concerned about until Dave started talking about it. So I want to
call.
look into that. You said a second one or just one?
If you got more you want to share, sure.
I'm also concerned about the custodial. Right now, there doesn't seem to be a whole lot of what they're doing with our custodial, but yet they're the ones that are experiencing a lot of different traumas in our area for some reason. And even though they have Vector Solutions, I think there needs to be more. So I wrote that I needed to find out what's working elsewhere and, in the trust that other people are doing that maybe I can learn from.
Right. Good. All right. Very good. Thank you for sharing. Anybody else? One more. Lori?
I have a new director of transportation that just went into the position. So I don't know if him. He's very eager to learn, very motivated to take the position and stuff. So far, I felt like we're going to process in place. We're going to have an I'd like to work with them.
Very good. Very good. Good idea. Good idea. Anybody else dying to share? Brendan? Nice. Good. Good deal. All right, last call. Okay. So we just want to say thank you for devoting the last 2 days to us, and we hope you got something out of it. We hope it was beneficial. There was a lot of information that was shared. We hope you enjoyed the fellowship with your colleagues, and please know that your colleagues there are to support you, and that's part of being a part of this family, and that you have individuals that you can go to as a resource, as well as the FISBET staff are really excited to be able to jump in wherever there is a need. So as you have developed your list here and you see that there's something that they can assist you with, don't be afraid to reach out. So we just want to say thank you so much. I think it was productive, and we really appreciate you devoting your time. If there's ever anything that we can do, or you have feedback from us about what needs to be done differently, we would love to hear from you, and we welcome that feedback so that we can continue to improve. So with that, I'll remind you that on the way out, sign up for a restaurant if you haven't so far. If you happen to be leaving us right now and going home, we wish you safe travels. And for the rest of us, we will see you in the lobby at 6:15. All right. Thank you.